everyone. Since we're already 5 minutes into our panel, we will start even though we're still in the transition phase. I'm very happy to announce today's panel on e-evidence by the University of Luxembourg. We're very happy to be academic partner of the CPDP since many years. And the Department of Law of the university is very happy to stage annually one topic somewhere between academia and practice, which is of high relevance, hopefully also of interest to all of you. My name is Marc. I'm professor of media and telecommunication law in Luxembourg, and it's a real joy to see that CPDP is thriving as ever, 1 year after the first year after the pandemic. So it's great to be here and exchange. Luckily, I do not have to say very much on content of today's panel because we decided we're talking about one of the e-sagas. So many of you know the e-privacy saga, which is a saga on the way to regulation maybe coming or not. But there is another saga which maybe is not so known to all of you. That is the e-evidence package, the regulation that finally was agreed upon at the beginning of this year. And therefore, we decided, because it's still a relatively fresh agreement and we are still waiting for how this is then finally going to be published in the official journal, we decided we would have first an overview given by my colleague from Luxembourg, Stanisław Tosza, who is an associate professor in compliance and law enforcement. But not only that, he's looking at the role of tech companies in law enforcement since quite a few years. And actually, I may make an announcement that very soon a handbook is coming out with Cambridge on digital evidence in criminal investigations. And therefore, Stanisław is the perfect person to, in a moment, give an overview just to bring us all up to speed. Where do we actually stand with this new legislative package of the European Union? And after that, we will have a panel discussion where we try to take the perspective of different angles, and I will start not exactly in the order as I will speak, but I would like to first introduce Erik Valgaeren, who is partner at Stibbe in Belgium. Why do I start with him? Not ladies first, not in the order, because Erik and I have been working more or less ever since University of Luxembourg is here at CPDP on putting together panels which both have a practice perspective, and besides that, Stibbe is one of the main sponsors of the CPDP, so we're very grateful that we are doing this, Erik. And for those of you who happen not to know him, which is very unlikely, he's one of the most active TMT lawyers in the field, and if you go back in history, the first big cases that were dealt with here in Belgium, you will usually find his name. Erik, I'm very happy we were managed to put together this panel again together, and I'm looking forward to the discussions. We have Vanessa Franssen from the University of Liège. She's professor there and co-director of the Service de droit pénal, procédure pénale et droit pénal international. But what is more important, Vanessa, I think, was one of the first persons that realized this e-evidence that is coming is going to change the game a lot when it comes to moving away from mutual legal assistance procedures to a new legal framework. And so of all of academic experts in Europe, I think Vanessa is at the forefront of people who are allowed to talk about e-evidence. So she will back up on what Stan gives as a first overview. And then we are very happy to welcome Marc van der Ham in the center, who has a double function in a way. One is very relevant because it shows the practitioner's perspective. He's the deputy team lead of policy and strategy at the Dutch Police Prosecution Services National Office. And in that context, very, very much involved with how will this change practical application in law enforcement. But he's also very interested academically, and therefore brave very much to do that besides his job, is a PhD candidate at EUL at the University of Leiden's Center in e-law, which means he can look at this question both from an academic perspective and how it plays out in practice. So great to have you here as well. And then finally, Martyna Kusak from Adam Mickiewicz University in Poznań will take the perspective of one member state where many of you will know there are certain rule of law issues in Poland. And it's interesting how the e-evidence regulation also plays a role in that context. I'm not going to say too much in advance. She's professor in Poznań, but in addition, she's also a collaborator at the University of Ghent. So we hope that this internationality of the panel and the diversity will ensure that we have an interesting discussion also with you afterwards. But first of all, Stanisław, I'm looking forward to your overview. The floor is yours.
Yeah, thank you very much, Marc, and good morning to everybody. I can just checking if this is working. Yeah. So I can imagine this will be, for some of you, this will be banalities or things that you heard already, but my task is to make sure that we are all on the same page for this file that has been around for many years now and developed quite a lot. So the problem of gathering electronic evidence came from a realization many years back that actually, if you think from the perspective of criminal procedure, there is a new player in the field. And this player has data. And this data is interesting for criminal procedure. So if you look back before technology that brought us to this place was so important or even came about, there was the post, and we sent letters to each other. The post never had a copy of our letter. They didn't do copies of our letters. For most of the letters, they didn't even know that they delivered them, because they would just deliver them, and that's it. They would not even keep a record, what we call now the metadata, that they did that. And now with technology, all this changed, and we have a third player, the neutral player, the service provider, that has maybe all the data or some of the data or at least metadata about this communication. So when the law enforcement realized, wow, this is a treasure trove, the question was, how do we access that? And the traditional way in criminal procedure to access such information from a third party, not a suspect, not a victim, is a production order. Hello, please give us this data. And you have some national procedural measures to do it. And here, the criminal procedure bumps into the problem of territoriality and the nature of technology, the nature of internet, of cyberspace, which knows no borders. Criminal procedure and enforcement in general knows very strict borders. So tonight, when I go back to Luxembourg by train, I will probably not notice, except that my phone will change networks, that I crossed the border. But the Belgian police or prosecutor will have to stop at that border and will not be able to go 1 meter across it to do any enforcement tasks. So the question is, if you have to ask a service provider who is not in your country for data, do you breach territoriality? Do you breach sovereignty of the country where this service provider is, or not? In principle, the answer is yes. Yes, because you're acting outside of your jurisdiction. So this is the essence of that problem. This gets complicated by several things. One of those things is cloud computing, and the fact that it's already nice if you know that there is a territory of another country where you should interact, where you should send your request, for example. But with cloud computing, you might not even know where the data is, because it's in the cloud, because it's been circulating, maybe because part of the email you want is on this server and another part is on another server in another country. Or simply because you have so many countries involved. You have Facebook, which is an American company, which has a data center in Sweden, and you're a Luxembourgish or Belgian or German prosecutor. So you have, for a very domestic case, a super international case where you just wanted to catch some guys who entered into some houses and stole some things from local victims, local houses, and local perpetrators. So that's the problem in a nutshell. Now, if you ask the companies, they also get into conflicts of laws. Because if they are active, for example, in Belgium, and they request, they have requests from Belgian law enforcement, at the same time, they have to comply with US law. This creates conflicts of law. So that's the second part of the problem. But what results also from the nature of technology and from the nature of, let's say, digital capitalism is that the service providers have an enormous power in terms of how they cooperate, what they want to give, how they, under which conditions they want to give the data. For the reasons I explained, the fact that the legal setting is complicated for law enforcement means that the service providers are much more in the driving seat. And this results also from encryption, because if you get encrypted data, there is not much you can do unless you really apply strong instruments, which as law enforcement you might not have the possibility to do. And also, these are very often very big companies who, in terms of litigation, have huge power to fight orders in court. To respond to this, we have a number of legal developments. Some of them are legal, some of them are not necessarily legal, like, for example, voluntary cooperation, this practice of just asking law enforcement and asking the service providers and counting on the fact that they want to be a good corporate citizen and don't be blamed for not solving crime. We had other initiatives. The second protocol to the Cybercrime Convention, development in the US law. But the major one, and this is our subject, is the e-evidence initiative. Something that started more than 5 years ago, let's say 5 years ago, with an initiative, but the discussion was even before that, so the discussion is much longer. So the idea is that the idea to create a regulation, a pan-European regulation, that would change the field, that would create the possibility for law enforcement in one member state to ask a service provider who is not in the same member state to produce data, and do it without the involvement of law enforcement in this other member states where the service provider is. And this is the essence of this proposal, which has been, as Marc already said, a long time in the pipeline. It was a true legislative saga, where you have the dates of different stages on the slide. But since January, we know that we have it, we will have it, it's finalized, the political agreement is there, and as far as I know, the file is somewhere between lawyer linguists and its way to the plenary for the votes, somewhere there. So I think before we go on our summer breaks, we should expect that this is voted and maybe even published in the official journal. So we will have it. So what is this instrument? It has two purposes. One purpose is to solve this problem in Europe. Whether it does so or not, it's a subject also of our panel. But this is the idea, that it creates a system where law enforcement can relatively easily access data from service providers who are active in Europe, in the European Union. They don't have to be European providers. It's enough that they are active in Europe. And the definition of service providers we have on the slide, and it will come back in the talks. So that's the basic premise. So it's supposed to solve the problem at the European level. But it is supposed also to give a chance to solve the problem with the US. And the problem with the US is that the major companies are subject to US law. And they are prevented by US law to give content data to foreign law enforcement without the decision of an American judge. They can give that content data according to the new Cloud Act at the condition that there is an agreement between the US government and the government of this other country from which the request would be coming. And now the interest is that the EU signs this agreement with the US, and the negotiations are already happening. The Commission has the mandate to pursue these negotiations, and the fact that we have this regulation gives the possibility for the European Union to sign this agreement at the EU level to avoid that the agreement is by every member state, which would give a lot of potential discrepancies between the details, and probably the time before we sign 27 agreements would be very long. This instrument is based on mutual recognition, which opens up another discussion about whether this is really mutual recognition, because it's very different from the traditional mutual recognition instruments like the European arrest warrant. It's a huge point to which we can come back in the discussion. The idea is that the data flows very quickly. So in principle, a service provider should be able to provide data within 10 days, and in urgent cases in 8 hours. And there are very limited grounds to refuse. So for the service providers can only refuse to cooperate if they have what I would call technical problems to provide data. They don't have that data. They don't know what the law enforcement means, etc. They cannot question the essence of the order, the proportionality, the human rights setting. During the discussion, there were ideas that they might be able to do it. They are not supposed to do it according to the last version. Whether they will anyway do it, this is something I will bring during the discussion. But in principle, that's not their task. And maybe last point, but because I think I'm coming to the end of the time I have, is the question about the position of the person concerned. So the person whose data is flowing will have remedies, but these remedies have to be provided at the national level, executed by the courts. So actually the information that the regulation gives us about it is relatively scarce, but it introduces a very interesting and in my opinion, fake instrument, which is the notification, which has been the subject of huge debates. And those who were following this file know that there were many ideas how to do this notification. So, for example, the idea is if some French gentlemen come to Luxembourg and they party a bit too much and they get into a fight with Luxembourgish locals, and then they go back to France, and then Luxembourg wants data from their phones, which come from Ireland because that's where the provider will sit. The question is how to safeguard the rights of these French nationals. So the idea is maybe we should send a notification to French authorities so that they can a bit act and safeguard the rights of these French citizens. But the result is different, and that's why I think it's a bit fake, because actually the notification that ended up in the regulation will go to Ireland. So the Luxembourgish authority will have to notify if they are asking for content and certain aspect of traffic data. They will have to notify the Irish authorities, who will be able to veto, to put it that way, the transfer of data. In my opinion, this instrument is not very useful because, either the Irish authorities, and we know that most of the service providers will be probably in Ireland, the Irish authorities will somehow become the policemen of this whole system, but why should they? Why should they spend their money on this instead of fighting crime, which they are supposed to do according to the role in Ireland? So in my opinion, if this doesn't concern some Irish interest, they will not really have an interest of doing anything. So they will just let the notification pass, the 10 days pass, and then after the 10 days, the data can go. So I think it's a fake instrument, but maybe I'm wrong, but that's my assessment of this. I think I will stop here.
Thank you very much, Stanisław. And indeed, that's subject to debate in a moment, whether or not this is a fake instrument. I think what has already been impressively demonstrated is there is a lot of complexity in this final agreement. So maybe there is a reason why it took 5 years to reach it. And Stanisław has pointed out quite a few of them. We will hear more what it means for practice. But before we do that, Vanessa, since you've been following it from day one, even before the proposal, where would you like to add also further issues that we have to take a closer look at when we now try to understand how it's going to play out in future?
Thank you very much, Marc, and pleasure to be here. Thank you to the organizers of this panel. I had 2 points that I wanted to, or 2 topics that I wanted to discuss with you today. First, address the question, does this eventually answer the questions that were there without stepping on, the field of my colleague to my right, who is a public prosecutor. But does this answer the needs of all the stakeholders, law enforcement on the one side and industry on the other side? And then looking forward, how will this new regime interact with existing national legal systems coming from Belgium? And for those of you who saw on one of the slides the mention or the reference to the Yahoo and the Skype cases, if you have some previous knowledge on this file, you may perhaps already guess why I'm raising that question. So first of all, a few elements on, does the instrument that will soon be formally adopted, does it answer what we needed? Well, what we needed, what the actors said they needed, because I don't need anything myself in this area. First of all, It does reply to the request to have a direct cooperation mechanism. So you have a judicial authority in one member state which will directly send its order, not a request, but an order, to a service provider in another member state. And that other member state will be the member state where the legal representative of this service provider will be designated. Whether this is mutual recognition or not, in my view, it is mutual recognition, but it's not the mutual recognition instruments that we are used to in the criminal law field, because there, with an EIO, for instance, European Investigation Order, we're used to having two member states, judicial authorities of two member states that exchange, that send their orders to each other and then execute them. This is more a kind of mutual recognition that we know from the civil and commercial fields of law, where if a decision is rendered by a judicial authority, whether or not a court, that decision has to be respected in the other member states, and you don't need to go through a new procedure to have it executed. So one goal has been reached. We will have a direct cross-border mechanism between a judicial authority of one member state and a service provider in another member state. How about the data? Because reference has been made to the fact that this is electronic evidence, and so this will help to solve a number of problems. You should be aware of the fact that even though reference is made to electronic evidence, also in the list of definitions, we're only discussing two investigation measures. It's preservation, quick preservation of data that is volatile, that might be deleted or destroyed or be changed. And then there's production orders. But all the rest is not included. So this is still a very partial approach to gathering digital evidence in the criminal law area. There have been some changes of terminology over time. Changes of terminology. The Commission proposed a new fourfold categorization with subscriber data, access data, transactional data, and content. Eventually, we come back to the old categories that we know, with one difference. That is that data that is actually traffic data but needed to identify, for instance, a suspect, will be treated as subscriber data. Now, one observation: subscriber data as defined in this instrument is not necessarily the same as it is defined by national systems, neither by other international systems. It comes very close to the Cybercrime Convention, for instance, but it is, in my view, not what the Court of Justice considers to be data regarding civil identity in its data retention case law. That is very detailed, and that probably some of you may know also very well. It's only regarding stored data. It's not future traffic data. So it won't be possible to say, as an authority, I want a service provider to follow a suspect in the next 2 months, which is definitely possible under most national legal frameworks. This is not possible with this instrument. Only stored data. This, of course, brings the elephant in the room. What if the data is not retained? So data retention is obviously not in this legal instrument and is yet a whole other discussion. It's only focusing, moreover, on communications data. Now, with the Internet of Things and AI and everything that is developing, and I think one of my colleagues will raise the question about future-proofness of this instrument, it's limited to communications data, whereas some national instruments will already go further. In my view, the Cybercrime Convention even goes further because it refers to computer data, which is broader, much broader than communications data. Okay, let me then turn to the second point briefly. How will this new regime interact with existing legal frameworks and measures? Well, this is a cross-border mechanism. It will only, in my view, be used to the extent that national authorities recognize that they are in a cross-border situation, which is what I always explain to my students. MLA is only used to the extent that, as Stanisław explained very well, law enforcement authorities know that they have to stop at the border. But for instance, in my own legal system, everything, nearly everything, is territorialized, which means that we pretend as if everything is happening in Belgium. So a production order is sent to Google, is sent to Meta, is sent to whatever other provider, and they are pretended, or we pretend that they are in Belgium because they offer services in Belgium, which is exactly the approach that is taken by this new regulation. But what will be done by national law enforcement authorities that already have these instruments at reach, use them on a daily basis very, very frequently, that ask for data immediately, in real time, that also have production orders that are not limited to stored data, and that are already pretty successful. I think, considering that the regulation doesn't say, everything that is happening or was happening before and that is not compliant with this new regulation should stop, it doesn't say so. So as long as national authorities consider that what they do is purely local, purely within their territory, they can continue to use their own instruments. Especially since there are very often measures that, for instance, don't have the same thresholds. Quick preservation under national law may be possible for any kind of criminal offense, is also the case under the regulation. But for instance, production may be possible, in my country is possible, as of 1 year of imprisonment, not 3 years of imprisonment. So you have an additional incentive why national authorities will just continue to use their own instruments. When will they use this new instrument? With service providers that don't cooperate. Like a Telegram, for instance, who never cooperates. But that raises another question that will have to be addressed at European level. Will Telegram designate a legal representative somewhere? And if it does so, then that will be the future. But I think so, and I will conclude on that national authorities will continue to work with their toolbox and will choose from their toolbox whatever instrument is useful, whether it's national law, whether it's this regulation. With Ireland, well, they will use this new regulation, but if they want to intercept or want to have future data, they will have to, not use the EIO, because Ireland is not in the EIO. They will have to use mutual legal assistance. And we still have to see what comes out of the negotiations with the United States, where there's also different thresholds. There's serious crime that is defined, which is not so incompatible, but subscriber data is defined in a more limited way, for instance. It's not limited to stored data, but it's also possible for interception. So we see that the complexity that we have had will continue to exist. Thank you very much.
Thank you, Vanessa, for this very, very clear illustration of how, even after this long term of negotiation, the instrument is likely not going to solve all the issues that have been the reason why the instrument was proposed from the very outset. And coherence between EU instruments is sometimes already an issue. But in this case, as you have nicely but also sadly illustrated, between the EU and the national level will be the very big thing. And in terms of the ones that have to apply it, Marc, it's up to you now to share with us how can or will this change the way that indeed evidence can be collected? So we are very curious to hear about that.
Yes, thank you very much. And also thank you again for the kind invitation. Well, I think it's already quite an achievement that at least the three of us don't disagree. I mean, there's nothing that you said that I have a completely different take on. So I think that's helpful. Just to make sure, I work at the Dutch National Office of the Public Prosecution Service, which means I might add some Dutch flavors to my comments. But it's also important to know that we focus, in our cases, on international serious organized crime, which might also involve high-tech cybercrime. And I think that's one issue I would like to point out as well. I think the package originates in the 2016 Council conclusions on improving justice in cyberspace. But we, as a prosecution service, obviously are applying and implementing this new instrument for all kinds of criminal offenses and criminal investigations. We have heard of big American tech companies that are largely incorporated in Ireland, but coming from the Netherlands, I can also say that we expect that many of the production and preservation orders will be directed at legal representatives in the Netherlands, which has a huge hosting sector and a broader internet sector as well. So I think that there will be some work for us and the Dutch police as well. Generally, we're very optimistic about the package. I think especially the time frames that are put in, the 10 days and the 8 hours, they will be a huge improvement to what are the current time frames. At the same time, we also have to be mindful of all the additional obligations, especially when it comes to the notifications that we will have to review. We're also optimistic that we might actually be able to find the legal representatives of the companies that offer the services within the EU based on the register that the Commission will publish. And also we're happy with the additional safeguards that were added to the package by the European Parliament. As you might know, the Netherlands made a general reservation when the general approach was adopted because there were some safeguards missing, and I think that the Parliament has included some very important safeguards to the package. Well, as Vanessa mentioned already, we do think this is a revolution in the way that we are conducting our criminal investigations. And well, we'll have to see where we are in 3 years from after it's been published. I want to raise 3 practical issues with you. The first one is the definition of what is a service provider. The second issue is a complex notion of resellers, and this seems to be a bit of a Dutch issue, so I might have to tell you a little bit more about it. And also the IT exchange system that we will actually need to implement throughout the EU in order to make the data or evidence flow from the service providers to the authorities. Now, first, what is considered a service provider? Obviously, the regulation does offer some hints by referring to existing legislation like the Electronic Communications Code, but also to the Directive on providing information on information services. But it's not as easy as it seems. For instance, let's take a company like eBay, which provides an online platform for selling products. Obviously, as a platform as such, eBay might not be in scope of the legislation, but when eBay facilitates the communication between a buyer and a seller, it might be covered by the definition. And those communication services within a broader service can be seen in other types of companies as well. For instance, in gaming. A gaming company is not necessarily for the communication between the players, but they might communicate. So this is something that we're already experiencing today, but will definitely be a matter of interpretation going forward. And how European member states will look at this issue, and whether they will look at it in some similar way, will, I think, greatly impact the speed of the instrument. Another issue, especially in cybercrime investigations, relates cryptocurrency platforms, wallets, exchanges. Financial services, as defined in a specific regulation, are excluded, but does it also apply to cryptocurrency providers? I'm not sure. Then there's maybe a little bit of an angle here, or a hook, where the regulation says, well, where the storage of data is a defining component, a service provider might also be included in the scope of the regulation. Well, when is the storage of data a defining component? Well, these are interpretation issues that we will have to deal with on a daily basis, and this will definitely impact the speed that the regulation will have. Now, the second issue I wanted to mention is the issue of resellers. Well, what is a reseller? A reseller basically rents a piece of hosting capacity from a hosting provider. And a hosting provider owns racks of servers that are basically or usually in a data center. Someone who owns a data center does not necessarily have to be the same person as the hosting provider, and the hosting provider is also not the same as the reseller. So there's a chain of service providers involved. Now, these servers that are in the data center, they're physical, but the servers can also be virtualized, and these virtual servers are usually resold by these resellers. And these resellers are usually not incorporated within the EU or in countries that are in the fight against cybercrime, but they might be somewhere else. So what happens if a reseller is addressed by a production or preservation order? probably the hosting provider will get the order, but the company will say, well, I'm not the controller of the data, so, well, sorry. There is no obligation in the regulation for anyone who receives an order to send it or pass it on to the correct addressee. Well, even if that is the case, how should we as a public prosecution service enforce this production or preservation order that is addressed to the reseller, because that reseller might not reply, it might not be in the Netherlands, it might not be in the EU, it might not be in any country that is, let's say, party to the Cybercrime Convention. Well, why am I mentioning this? Because we expect that many countries within the EU that will send these preservation or production orders to Dutch data centers will basically get a no, because they are not the controllers of the data. Well, this is another matter of market regulation, a bit of a hobby horse, but I think a very big one, because in the Netherlands the hosting sector is unregulated, and this means that these resellers can, well, do a lot of business in the Netherlands, but might not be approachable or responsible. Then, finally, the decentralized IT exchange system. This is something that I believe the Parliament added at the end of the negotiations, and it makes sense. You know, why would you have a legal instrument and not have a way to actually exchange the information that is being ordered? At the same time, we also know how IT projects are usually executed, and especially that since the European Commission has around 2 years after the regulation is being published to come up with sort of reference software where we can build this IT system on, I'm a little bit worried. And especially we need the dialogue with the industry, because as law enforcement or as the police community within Europe, we can have all kinds of expectations of what these service providers should do, what type of data formats they should deliver the data in, at what time or whatever. If the data or if the service providers have a different idea about this, the instrument doesn't work. So this is something that I'm concerned about. I think from a legal point of view, yes, we will have to make a lot of adjustments as well to the Dutch Code on Criminal Procedure. This might be necessary in many other EU member states as well. The negotiations with the US might be very cumbersome for, I think, very valid reasons. But if we forget to build this decentralized IT system, it's not going to fly.
Without wanting to sound too pessimistic, Marc, you actually added new layers of issues that are coming up. And this is interesting because all of this is in our minds already before we even have the published version of the instrument. And I sometimes wonder, but that's just a personal comment, that those that called for a facilitation of their daily work in this context will now be burdened with additional work without knowing whether the facilitation will help. So starting out from the IT system that you mentioned last, but also the reacting to these information notices. So that's already quite challenging. Now, we don't only have the public prosecutor side, we obviously also have the lawyers that on the one hand work together with these companies that are concerned with all these types of requests that they will get, but also, and I'm glad that Erik is also going to put a focus on that, there is a question of how can a lawyer work together as in traditional exchange means with clients if it's not clear what happens with the legal privilege. So maybe, Erik, from the two perspectives as the business client representative, but especially also as the lawyer of these companies, we are curious to hear your view.
Thank you very much, Marc. Obviously, in legal cases, any evidence is good until it's not. So I think when the core problem we are trying to address here is to ensure that we actually facilitate evidence collection, evidence gathering, the key imperative should be that we are more comfortable about the quality of the evidence that we will obtain by following these processes. And when I actually read the document, my first reaction is, oh boy, we are going to have fun with this. And obviously I could talk about this for a bit longer than the 8 minutes allocated to me, but I'll bring a few points based on my own kind of practice and profile. The first one is the data remit or the data dimension of this instrument, including various concerns I have about the correlation with GDPR. The first one is a point raised already in passing by Vanessa, which is this brand new category of data that is being introduced, called data requested for the sole purpose of identification only, right? It's not about data used for the sole purpose of identification. It says data requested for the sole purpose. Now, maybe a parent I want to open, and it's a point that Stanisław rightly mentioned before we got in. There's still a cleanup being done of the actual language. So I don't want to be like overly picky about words, etc. But from a right evidence perspective, words are important. So I will focus on the language as proposed. But so data requested for the sole purpose of identification only. Now, the presence of this category of data is really very key, because you can actually see it in the text. I think it's repeated 36 times. It impacts whether or not a judge will be involved. It will impact the materiality threshold required in terms of ability to access the new instrument, meaning for this kind of lowerly considered category, you can already trigger a request as for crimes punishable with only 4 months of detention, instead of the general rule, which is 3 years of detention. And also the notification obligation is impacted by the question whether or not you are working in this data category or other traffic or content data. So it's not an incidental point. It's a key point, this new category. The underlying rationale is the quest for IP numbers. The motivation clearly spelled out in the preamble says that the reason we do it is because of the importance of getting easy access to IP numbers. But strangely enough, and that's why I think is a very important consideration, it literally says in the preamble 22b that these IP numbers are not considered to be privacy intrusive. Which I find a very funny statement to be made in this instrument. Obviously, it's written, I think, not necessarily by GDPR experts, but the question is, how will this all play out if later on we are dealing with this instrument? Because an IP address can obviously reveal much more information than just identity. When properly framed, you can use it also to identify where somebody is, right? Location. And what if it's, requested and then later on used for something different? How do you then deal with the fact that you've had all these guarantees which were not applicable because you were actually aiming at this kind of lower protection level instead of the bigger protected traffic and content data? The definition of, because it's in the document, of what is data requested for identification only, it's pretty broad. It would definitely include IP addresses, also all other technical equivalents, whatever they could be, where necessary, together with all the relevant source port and timestamp information. So this is really very interesting, and has no bearing whatsoever with, for example, what we consider to be sensitive or not under GDPR, the special category. So that's a first, I think, problematic dimension GDPR-wise in this instrument. The second one is the controller versus processor dimension. It always comes back in every GDPR debate, but it's addressed explicitly in the preamble. And the point of departure seems to be that the instrument, the order, should aim at service providers acting as controllers. As recognized in the preamble itself, often it's not very clear who is the data controller in technology-related settings and platforms. But then, I think there's a kind of self-serving mechanism in the document, because it says, if it's not reasonably possible to define who is the controller, let's still go after the service provider after all. So we kind of think we should go after service providers that are controllers. It may not necessarily be possible to identify who is the controller or decide whether he's a controller, but then still, you can go after the service provider. Obviously, the consequence is going to be huge, because then it means that if de facto the service provider is a processor, he will also have all the notification obligations towards the data controller, unless then, in the order, he's prohibited from doing so. But if they actually add that, then they make the assumption that he's really not a controller. So it's going to be, I think, complicated. Another interesting point is user. You know, there's some definitions in there about users. There's also a concept of persons whose data are sought. In my view, not necessarily just the only data subjects involved, but data subject as a concept is not addressed in the instrument. So what about their rights? Question mark. And the final point I wanted to make is the retention obligation, or I would say the restriction to just keep holding on to data, because if you have a preservation order against you, it's not necessarily limited in time. Actually, it's up to the issuing authority to tell the service provider when it's no longer necessary to hold the data that they can stop holding the data. So what if they forget to notify the service provider that it's no longer necessary? Because in the meantime, and after that, it's still there behind on the line. They will have to account for what they're doing with the data. And so the question is, how does this all fit together? There are more concerns for service providers than just these GDPR points. I think Marc already introduced the idea. It's a very broad concept. So platforms who until now have had nothing to do with evidence collection, especially from an international perspective, don't know anything about MLAT, don't know anything about Cybercrime Convention, they suddenly kind of face this system. And it's really a lot about conflicts of law. I mean, they will have not necessarily an idea what the state of the law is in the issuing country, for example, and what the document is they're receiving. And still they will have to be able to separate what I call the good from the bad from the ugly. And they will be put on the spot, like happened in the Yahoo case, but unfortunately not all these service providers will be Yahoos and will be equipped to deal with all that. The timelines can be problematic. And the last point I want to make on their behalf is, how about the sanctions? The sanctions, Article 13. There's even a financial sanction that is imposed, i.e. member states need to be kind of providing for financial pecuniary sanctions up to 2% of the worldwide turnover of the service provider. Interesting question as well, 2% here, 4% under GDPR, 6% under the DSA, 10% under the DMA. Maybe at some point as a service provider, you will be kind of mitigating your risk and you will be gaming, you know, where is the lesser risk for me? Will I breach this one or will I prefer to breach that one just to be on the cheaper side of sanctioning? We'll see. Legal privilege, and I will pause there. Legal privilege is a cornerstone issue when we come to systems dealing with evidence. Obviously, again, the document recognizes the issue, but it doesn't necessarily address it in the best possible way. The first problem is, it's going to be the issuing state who in the first time is invited to consider whether or not privilege is involved under the laws of the member state where the service provider is addressed. So issuing states need to think about legal privilege in the target state, the member state where the service provider is addressed. And then they may seek clarification from the enforcing state. They don't have to, they may do it, right? Now, in cross-border cases, I mean, I'm a member of the Bar of Brussels, of Luxembourg, and of New York. You know, it's not because my data or my communications with my clients are going through a Dutch system that Dutch law will determine the level of the privilege applicable, because I'm a member of the bar here in Brussels. That is the law that determines the level of privilege in the communications between me and my client. So as in the case of Stanisław, he positioned this kind of cross-border situation. We may not be doing the right triangulation in terms of what the reference jurisdiction should be to actually check on privilege. And again, upon receipt of the order, the addressee can also raise to the enforcing authority an issue of privilege under the laws of the enforcing state, which again may be the wrong jurisdiction to be addressing it. I will pause here. I will just simply confirm the point that Marc made about the kind of disastrous situation we may get into from an IT perspective. IT projects from this size and complexity, they have a tendency to just go wrong. And even if they're functioning properly, will they be properly auditable, and will there be tracing and logs and everything, so that if I as a defense counsel want to challenge the whole flow of things, will I be able to do that? Question. Thank you very much.
Thank you, Erik. And interesting that a harmonizing instrument actually calls for more comparative law education at universities to understand what is happening even within the EU member states. And in a way, that's the perfect bridge to Martyna, who will deal a little bit with the question of, and where does the judiciary come into here, and the question of judiciary independence when it comes to questioning what the role is in another member state, but also from an EU perspective. So Martyna, add complexity.
Thank you very much. I was asked by the organizers to bring some very specific perspective of judiciary being questioned and how it will impact on the future application of the e-evidence package. Given the timing, I promise to be very brief, and maybe I will start from introducing some core aspects of why do we have judiciary independence questioned in first place. So it all happened in 2017, where totally against the rules which are written in the Constitution, the political party reorganized the main body which is involved in judicial appointment procedure, which is now made up by representatives or people very closely linked to legislator or executive. And that step started a domino effect on the entire judicial system, because in first place, every judge which is now appointed by this body, and this is the only option at the domestic level, can be questioned. His or her legitimacy can be questioned. And so the judgments which are issued by such judges, and they are already cases issued by the Supreme Court, which, by the way, very heroically fights to stay independent, which lift the judgments of the judges who were appointed by this body. So from a regular citizen perspective, it is a lot of uncertainty about the future of the judgments which are made, and also from the judicial perspective, it is a lot of questions about their legitimacy and the future of the judgments which were issued by such judges, which were appointed by a body which was formulated against the basic rules which are written in the Constitution. So now how this links to the question of the e-evidence package and its application on the future. Well, it is not the first time that the EU has asked itself the question what to do with a country which has some rule of law concerns. And the first attempt to provide with some procedure was in the context of the European arrest warrant, where the Court of Justice of the European Union ruled that in case the European arrest warrant coming from a country dealing with the rule of law crisis is issued, the executing authority should not automatically refuse such warrant, but it should make a lot of work and verify whether in this individual case there is a risk of having the fundamental rights breached. So this approach has also been expressed in the EU evidence package. If we look at the preamble, recital 42D, there is a lot of analogy to this judgment, and we can read that orders coming from countries such as Poland and Hungary should not be refused, but it should be determined specifically and precisely by the enforcing authority whether they are substantial grounds for believing that the person who is at stake will that there's a risk that the rights of this person are questioned. There is a huge question about how this EU evidence package prevents from abuses, or how this framework could be called effective. to cooperate with countries which deal with the judiciary independency crisis. And well, I share the point of view of Stanisław that the notification process, which is the first step, because in this package we do not have the enforcing, the executing authority, we have enforcing authority, and the first step to run any kind of procedure which would prevent abuses is to be notified about this situation, and the notification is voluntary. It is very narrow, and it is still up to the issuing authority, whose independence can be questioned. So this is the first problem. And the second problem, there is a ground for refusal in the regulation, which says that in case of the risk of fundamental breaches, in exceptional cases, the enforcing authority can refuse the execution of the order. And again, whether or not the enforcing authority will be informed about this situation will fully rely on the notification process, which is again up to the issuing authority, whose again independency can be questioned. So there is a lot of questions about the future of this package of the legislative proposal, and how it can really prevent from abuses. As a Polish citizen, I'm not in a position to question every judgment that which is issued by the judges which are appointed right now by this body. But I must say, just to give you some perspective, that there are already 2,600 judges who are appointed illegally by this body, and some of the judgments which they issued were also questioned at the domestic level. So just to put one more concern about the complexity and bothering service providers who will be involved in this procedure, maybe the entire effort will prove pointless because of the mess at the domestic level, because I believe that more and more judgments will be lifted by the Supreme Court, and that would mean that the entire proceedings would have to be restarted. So I am not very optimistic about the application of this regulation at the domestic level. It will just be a nice gift to our authorities, who will have the opportunity to access data which would normally not be able to reach, or it would be very much more difficult for them. And now we will be dealing with this endless question of what to do with the judgments which were issued by the judges who were appointed by the body which was reframed in unconstitutional manner. So we will see how it works. And just to make some analogy, because I mentioned the European arrest warrant, however, an important point of departure should be the European investigation order, and the fact that in this context they were not, at least I am not aware of any case at the EU level. At the domestic level, maybe there are some issues, but I'm not aware of any in which the judicial independency would be questioned in the context of transferring evidence in the EU. So there has been a lot of discussion, a lot of debate in the context of European arrest warrant, which involves transfer of persons, but there have been no issues whatsoever, at least that I'm not aware of any, which would question the rule of law and the judicial independency in the context of transfer of evidence. So we will see how the EU evidence package will work and whether or not it will be effective in case of any kind of abuses, preventing abuses. Thank you very much.
Thank you very much, Martyna, both for your open and very clear words. I think it is also important to consider that in addition to the practical difficulties, in addition to the problem of interpretation that has been highlighted before, we also have this question of how do we deal with divergences to call it more neutral between member states and how they will apply this instrument. I think that is very important. We had agreed that there's one point that definitely needs to be covered as well before you can warm up for questions from your side, and that gets back to Stanisław. In all of this setup, we've been talking about public prosecutors, about courts, about law enforcement authorities, but the real big actor is private parties, right? And why do we have an issue with that, Stanisław?
Thank you, Marc. The question here is it privatization of justice? Because this was one of the things that were said when this proposal was formulated. This is privatization of justice. But before entering into this question, we have to take into account that before or until now, or this instrument is a response to a lot of uncertainty, which result in voluntary or quasi-voluntary cooperation with the service providers. So a cooperation which is based on the fact that the service providers are willing to provide data within the legal framework that's possible, but also within their goodwill. Which means that they assess in many situations whether they like the order, whether they find it legitimate and proportionate. So this instrument is meant to bring also back this to a legal framework. So there is this conflict. Is it privatization of justice? And I think that actually the platforms will remain in the driving seat to a large extent. According to this instrument, and for a number of reasons. So, of course, for unproblematic cases, the data will flow. This is not about unproblematic cases. But if I pick up the point from Martyna, where we will have cases that come, for example, for countries that have a problem with the rule of law, or requests for crimes that are not necessarily considered crimes in other countries, where societies are divided and take different positions, or sometimes the governments impose laws which are not necessarily according to the will of the majority of the population. How will providers react to requests for data which would allow to punish for those type of crimes? And now I will come back to the notification. Notification not only is this fake instruments that I said before, but it is not used if we're talking about subscriber data or data requested for the sole purpose of identification. So the notification is not even sent, and even for content data, it doesn't have to be sent if we're talking about a domestic case, and we have a definition of a domestic case. So there again, it is not mandatory. So if in many instances the other authority will not even know that a request has been sent, of course that authority, I already said, might not have an interest, but they might not even know that this is happening, which means that all lands on the desk of the service providers, and they will have to, or maybe want to, react. Because if they find themselves cooperating with a government that is seen by the majority of their clients as bad, as pursuing things that should not be pursued, they might be motivated to say, no, we don't want to give data, and we will refuse. And if you sanction us, then go ahead, we will litigate, because we can. And we have already examples from in different contexts that they can do it. The famous case of Apple against FBI, which was about a domestic terrorism case. So hard to imagine a heavier accusation than that one. And they said, we will not open the iPhone of the dead terrorist to check if he had contacts, because this is our principle, we will never open the phone. So they use it. You may say, okay, they preserve privacy, or maybe they just act in their business interest because they want to reassure the clients, so whichever way you interpret it. The fact is they didn't hesitate, and they went to court, and they were ready to be sanctioned because this was more important for them, and they can do it. And the result was that the FBI had to contact hackers to just hack into the phone, which resulted that they found nothing. But the fact is they will not hesitate to do it. So I think this instrument keep them in this driving seat, and especially the notification, the limits of the notification, even confirm it that way.
Thank you for adding that. I think that is a very important point also for looking at the future litigation. You mentioned, Vanessa, the data retention case law, and I see very, very surely a similar case law having to build up once the e-evidence is in action. Question will be how long will it take to get to a similar detailed view than we are now with data retention. We won't regain our 7 minutes that were taken away from us at the beginning, but we would still like to see whether there are questions from the audience. So if you feel like asking a question, please go to the mic, briefly who you are, and ideally a question, no comment, and address to whoever you want to ask. Go ahead.
Hi, I'd like to thank the panel. My name is Aislinn Kelly and I'm the Assistant General Counsel for Microsoft, and I work in this area on a daily basis. We are incredibly, I think, optimistic actually in Microsoft in relation to the e-evidence, because we believe it's a really good way of ensuring that there's a clarity of law for European citizens in this area. I think I've just two remarks to make. First, Marc, from the Dutch Prosecution Service, you made a remark about the decentralized IT system, and obviously I'm very aware of how much work that's going to take. It may be of use for you to know, and for other perhaps public prosecutors who are in the audience to know, that work on scoping that project has already begun. And I'd urge you to contact DG Just in the Commission, because they're the ones who are going to be driving that implementation of the decentralized IT system. And then secondly, my remark to Vanessa, just in relation to, I suppose, your observation about whether national police agencies and prosecution services are going to continue to utilise their domestic legislation to serve orders on service providers. They may make that decision, but I think probably looking at the landscape from a service provider perspective, that the decision will be made to not comply with those orders on the basis of e-evidence providing a legal obligation on the data controller. So, I mean, I think that will be fertile ground for conversation with prosecution agencies and police agencies around Europe. But I think the way things stand is that maybe become basically obsolete, because the e-evidence regulation will provide a clear legal basis. So. I appreciate they're neither questions, but they're just, I think it's such a fertile ground of conversation. I do thank you genuinely for bringing up issues. I've read this legislation over and over again, and today I've even come across things which have sparked my thought process. So really great conversation.
Even though it's a comment, it still will it will allow for a response. We come to at the moment. Maybe we'll collect one other question if there is another one. Otherwise, maybe, Vanessa, you do want to pick that up, and Marc as well, not necessarily in the sense of an answer, but a reaction to the points made.
Thank you very much for that comment. I was already kind of expecting that reply from a big player like your own company, but this may not be the reaction of many other service providers, of course, who don't have the same means to say, you know, we don't comply with this one, especially that national provisions provide for criminal sanctions. So the service provider who doesn't comply with the order can be prosecuted themselves and brought before trial. And so, you know, but I think there will be an interesting dynamic unfolding itself, that's for sure. And if big players like your own company will push the national authorities to use this cross-border instruments, that would probably be a good let's say, dynamic that will unfold. Notwithstanding other differences, for instance, also in scope, like Marc said, service providers that allow their users to communicate. In Belgium, for instance, Uber is considered to be a service provider that provides communication services. We will see whether all those providers that are already considered to be in the scope will also be considered to be in the scope of e-evidence. If they're not, if a more narrow interpretation would be taken, then of course you will still have this. But it will be very interesting to see what will happen once this instrument is in place. And thank you for your comment.
Marc, what do you know?
Yeah, maybe just a little bit more step aside. I think that our experiences with large companies are by and large very positive, including the big company represented here. But we also have a lot of smaller companies that might have difficulties in understanding what this legislation is all about. And in the Netherlands, we have a association for smaller ISPs in order to execute a intercept warrant. So they might actually also have the opportunity to pool the expertise, maybe have legal counsel or some kind of code of conduct, code of practice towards this piece of legislation, which we would obviously commend.
I appreciate that. I think what we will do in view of the time, we'll take that one last question, and then the ones that have not answered yet any question, if that's the case, get one last comment to make. Juraj.
Hi, Juraj Seifert from Vrije Universiteit Brussels. I have a question for the Dutch prosecutor, because I think you were mentioning the cryptocurrencies and whether they are actually falling within the scope or not. So I was wondering whether you looked at the relationship between the new anti-money laundering package that is being negotiated that actually brings them in the scope of that reporting obligations to financial intelligence units and the e-evidence and the interaction between the two.
Yeah, definitely. And I haven't finalized that analysis yet, but I see the merits in comparing those, definitely. Yeah.
And I actually think that is the next big mapping exercise we will have to be doing, to put next to each other also from the perspective of the operators, which obligation under which instrument and how do they interact with each other. Maybe Erik and Martyna, the next months, once it's published, what is the thing that we have to look out for most, besides what you have already mentioned? Where do you see the first attention that we should direct to when looking at the application of the instrument in practice? Maybe Erik first.
For me, I think the first point of attention will be the education. It's really the education of the different stakeholders, not in the least the smaller service providers, because my assumption is that the bigger ones, as I know, have already pretty much their head around a number of the issues, but education, awareness, etc., etc. Dashboards.
Thank you. Very important as well. And Martyna, I mean, you clearly already indicated we will have to be looking at specific member state cases in practice, but maybe also to add on that, we don't want to wait until the first case is brought to the Court of Justice. Is there anything that can be done in advance to kind of mitigate in advance potential problems?
Yeah. I believe this instrument will be used, and maybe I didn't put it very clear in my presentation, but among those more than 2,000 judges, there are also judges who are doing their job, and they are doing their job greatly. So it's not that everyone now is politically driven. So I would keep my fingers crossed for those judges who will be in charge of explaining their independency, and I would very much welcome the openness of the service providers and enforcing authorities in verifying whether or not this specific order coming from specific judge should be refused or not.
Thank you very much for that. And I have to say, for me as a moderator, it was a privilege not only to moderate today, but when we composed the panel, I already had a very high level of expectation. It was clearly excelled on how many different layers of complexity you would present. The idea today was, because in 1 hour, 15 minutes minus the 7, we cannot do very much more than actually illustrate those difficulties that will come up. When we were debating the panel, we said, what we definitely need to do is we need to do a follow-up conference on the topic of, now that it is published itself, not necessarily at CPDP. We come back maybe next year and look at the first experiences after application, but we will definitely organize a conference in this dimension in Luxembourg, because we can, I think, refer back in history that a couple of years ago there was the justice ministries of the Benelux countries and the commission that attended a conference in Luxembourg, and in the back rooms they were debating then the e-evidence proposal as an idea, and maybe it's justified to return back to those rooms and say, now it's there, what does it mean? I think the panel has demonstrated the perfect composition, great expertise. Thank you for being so clear, and definitely this was only the beginning of the conversation. Thank you for holding out beyond 4 minutes, beyond the lunchtime, and thank you, and join me please in thanking the panelists.